Welcome to EUPrivacyForAll, Session 17 on GDPR, Article 21, the right to object. Article 19 was finally renumbered 21 on the right to object. It lays down that the data subject shall have the right to object on grounds relating to his or her particular situation at any time to the processing of personal data concerning him or her, which is based on public interest, legitimate interest, including profiling. The controller shall no longer process the personal data unless the controller demonstrates compelling legitimate grounds. Where personal data are processed for direct marketing purposes, the data subject shall have the right to object at any time, and it includes profiling to the extent that it is related to such direct marketing. In paragraph 3 of Article 21, it is stressed that where the data subject objects to the processing for direct marketing purposes, the personal data shall no longer be processed for such purposes. The following paragraph insists on the fact that at the latest, at the time of the first communication, the right to object shall be presented clearly and separately from any other information. The following paragraph lays down that the data subject may exercise his or her right to object by automated means using technical specifications. Whenever there is a scientific or historical research or statistical purpose, the data subject, on grounds relating to his or her particular situation, shall have the right to object, unless the processing would be necessary for the performance of a task carried out for reasons of public interest. Recital 59 enhances 3 key points. First, modalities will have to be provided for facilitating the exercise of the right to object. Second, the controller will have to provide means for requests to be made electronically. And finally, the controller will be obliged to respond to requests of the data subject without undue delay, that is to say, at the latest within 1 month, and to give reasons for not intending to comply with those requests. In Recital 70, regarding direct marketing, it is once again highlighted that the right to object shall be explicitly brought to the attention of the data subject and presented clearly and separately from any other information. As laid down in Recital 73 and 156, Member States will have the possibility to provide specifications and derogations in their national law regarding the exercise of the right to object. Articles 13.2b and 14.2c also remind that the controller will have to provide the data subject with information regarding the possibility to exercise his right. The Directive 95/46 in Article 14 on the data subject's right to object lays down that the Member States have to grant the data subject the right, at least in the cases referred to in Article 7e and f, that is to say, public interest and legitimate interest, to object at any time on compelling legitimate grounds relating to his particular situation to the processing of data relating to him, save where otherwise provided by national legislation. There is also this right to object on request and free of charge to direct marketing processing, or to be informed before personal data are disclosed for the first time to third parties for those purposes, and to be expressly offered the right to object free of charge to such disclosures or uses. Member States shall take the necessary measures to ensure that data subjects are aware of the existence of the right referred in this paragraph. What should accountable data controllers and processors get prepared for? First, keep in mind that the right to object applies only on grounds relating to the particular situation of one specific data subject. and based on the grounds of public interest or the official authority vested in the controller or the legitimate interests of the controller. This right can be exercised at any time, free of charge, and specifically regarding processing aiming at direct marketing purposes, including profiling. The controller shall no longer process the personal data whenever a right to object is exercised, unless it demonstrates compelling legitimate grounds, that is to say, for instance, defense of a legal claim or scientific research of public interest. The controller should provide means for requests to be made electronically. It shall also respond without undue delay and at the latest within 1 month. And finally, give reasons where it does not intend to comply with the data subject's request. Finally, data controllers will have to bear in mind that member states can provide restrictions, derogations, or specifications to this right. So the key question now is knowing more about the intention of member states regarding those specificities and EDPB or court's guidance on how to demonstrate compelling legitimate grounds.